Good afternoon, everyone, and welcome. Thank you for coming to the seminar today. The seminar is on EHCP appeals, what schools need to know to participate effectively in these appeals. We are hoping that it will give you a bit of an overview on what happens at an appeal hearing, because it is something that is obviously concerning the schools at the moment. I am a partner in the regulatory and compliance team, specializing in education law, and Rosie is a solicitor in our team, also specializing in education law. Now, the reason for choosing this topic, and Taima, if you can move to the next slide, please. The reason for choosing this topic is due to the fact that we're getting more and more questions on the topic of a school's attendance at SEND appeals. The latest SEND tribunal statistics show a very sharp increase, 78% increase in appeals compared to the same quarter last year. So SEND appeals are not going away, they're increasing year on year, and this is putting pressure on everyone, local authorities, the schools, and more importantly on families as well. The tribunal, between April and June this year, the tribunal recorded almost 6,000 appeals hitting their inbox. Is the biggest ever quarterly increase. This is perhaps unsurprising in the context of cost management schemes such as safety valve agreements and delivering better value incentive strategies, and how these are impacting families and schools and the ability to meet need with the funding that the schools are receiving for EHCPs. So the reality of all of this is that your staff at schools are increasingly being asked to participate in appeals, often at very short notice and with little assistance from local authorities. Sometimes the schools are being asked to participate by parents. And again, it's not the role of parents to guide schools on EHCP appeals, and parents themselves find hearings very stressful. I have personally conducted hundreds of SEND appeals, both for parents and local authorities, and I see how anxious everyone is around the appeal hearing, etc., not only in terms of preparation for the hearing, but also on the day of the hearing. So the purpose of the talk is really to give you an overview of the appeals with some practical tips on how to prepare best for these, and then also to we're aiming to conclude the talk early so that there's plenty of time for questions. We're hoping to be done within the hour, perhaps even a bit less than that. That's our aim anyway. So please do pose your questions using the Q&A function, and we will come to them at the end of the talk rather than during the talk. Rosie will now take you through the agenda for today and start the talk for us. Thank you.
Good afternoon, everyone. So today we're going to really take you through the life cycle of the appeal and giving you the practical tips for your attendance there and in the specific context of the school's role in that appeal. So looking at the types of appeals, how you may ask to be involved, be that through witness statements, and then how you can prepare yourselves as a school to attend an EHCP appeal hearing. We'll then look at what happens after the hearing, and as Miriam said, there'll be a time for questions at the end. Next slide, please, Tamar. So we've set out here for you the statutory framework that applies, and so I'm not going to go through this in detail with you, but what I will flag to you here are the tribunal procedure rules, just at the bottom of that second list. And as well, the first tier tribunal also produces some relevant guidance. And so if you do ever want some additional information, this is available through searching for SENDIST guidance. And there's a whole raft of forms and various guidance and procedures that will give you some understanding of the tribunal process. Next slide, please, Tamar. So what we've tried to do here for you is to give you a bit of an overview of the whole tribunal process, because obviously as schools, you may be brought in at different points, and so you may not have that whole overview of what is happening. And so for those who have been involved with disability discrimination claims, there is a similar process that's followed here. And again, the onus is on making the process as parent-friendly as possible. And so there's an onus on the local authority, again, to be preparing bundles and documents. It is important to note, although we've included timelines here for you, it is a dynamic process because of the nature of what's being looked at. And so it may be the case that there are adjournments, there are delays, and that really depends on a case-by-case basis. And of course, we know that, as Miriam said, there's a huge amount of cases being looked at by the tribunal, and so it is, of course, subject to their capacity as well. So we'll leave this here for you in case you would like to refer back to it at a later date. Next slide, please, Tamer. So what are the types of appeals that can be brought? Well, we've set these out for you on the next couple of slides. So this slide contains the types of appeals that you as a school will be much less likely to be involved in. So for example, a decision by the local authority not to carry out an EHC needs assessment or reassessment, a decision that it's not necessary to issue an EHC plan, or a decision by the local authority to cease to maintain an EHC plan. Of course, there may be cases where schools are involved, but on the next slide, we've set out those that a lot of you will be more familiar with. So next slides, please, Tamer. So here are the types that you are more likely to be involved with. So for example, an appeal, again, about the child or young person's special educational needs as specified in the EHC plan. So in practice, that's section B. Section F, which is that how that special educational need is specified, or special educational provision, sorry, I should say, is specified. And then as well, section I of the plan, which is the section that names either the school or type of institution or school to be named in the plan. An appeal can also be brought for an amendment of these elements, as well as a decision by the local authority not to amend following a review or reassessment, as well as recommendations on health and social care. Next slide, please, Tamer. So we'll just pause here quickly with the SEND appeal process, because we'd like to take you back just to the EHCP consultation process, which is often, or it can be, one of the first times that a school is made aware of the needs of a prospective child, or where the LA is proposing to name the school. And you'll see here that the slide is prefaced on circumstances where a school would like to challenge being named in an EHC plan. And so we've set out here for you the legal test that will apply and that you will be addressing as part of your response to a proposal to name the school. And in practical terms, it could be likely to be the same person who's preparing the EHCP response as it is who will be attending the SEND appeal. And so it's really important that whoever is doing that is really familiar with this legal test in order that they can provide relevant information. So that test then is the school must consider whether the placement would be unsuitable for the age, ability, aptitude or SEN of the child or young person, or the attendance of the child or young person there would be incompatible with the efficient education of others and or the efficient use of resources. So that is the legal test, but what does that really mean in practice? Well, the threshold for meeting this test is really high. And so any response that is provided by the school needs to be detailed and comprehensive and really digging into the granularity of each aspect. Really importantly, it needs to be highly tailored to the child in question, and so it can't contain general statements about why the school is unsuitable, for example. It needs to specifically consider the interventions, support, resources for that particular child's special educational needs. It needs to be looking at risk assessments, so what needs to be put in place to support that child and others. It should be looking at really carefully costed budgets to show the cost of putting in place the level of resources support that's required for that particular child. Specifically looking at the efficient education of others, the school needs to be looking at who will that child be coming into contact with on a regular day-to-day basis in their peer group, and how will they be prejudiced, and whether that prejudice is so great that it will be to make it incompatible with providing education to others. So, for example, through your health and safety risk assessments, looking at teachers' time and resources, any safeguarding risks, and demonstrating specifically which children will be effective. And then considering all of the above, what reasonable steps can the school then take to put in place those adaptations, and what isn't reasonable for the school to do so? And so we've addressed this here because the consultation response is extremely important at this stage, because if it's not sufficiently robust, then there isn't a second chance to submit further reasons to the LA. And as we'll look at later, it can weaken the school's position if it would like to mount any future challenge. I'll now hand you back to Miriam to look at some of the practicalities of the SEND appeals.
Thank you, Rosie. Thank you for that. So often one of the first times that schools know that a matter has progressed to an appeal by parents following consultation of the school is when the local authority, often the local authority, contacts the school and asks them for a witness statement. That often is the first time, and schools are not generally well prepared for this, in that you're not legal services providers and not involved in these things routinely. And the first thing to do for you, well, first of all, you understand that you do have a duty to cooperate, and that's being brought in by the SEND Code of Practice. The second point is you must always ask the local authority when they email you a template that you may or may not use. You don't have to use the templates. Asking you for a witness statement, you can clarify on what grounds the appeal is being brought, what sections are under appeal, and please may I have the relevant documents. It's not fair or appropriate to ask a school to compile a witness statement without knowing what the appeal is about. The second point is you can clarify the purpose of the witness statement. Are they going to ask you to attend the hearing? The likelihood is, if they're asking for a witness statement, they are expecting you to attend the hearing. And the tribunal will normally expect both the schools, the school of parental preference, where there is a dispute, and the school of the local authority preference, or the school where the child is currently at, if we're looking at section F and B issues. The tribunal will expect the schools to attend, again, because there is that duty to cooperate and to act in the best interest of the children, and schools are best placed to comment on the child's needs and provision reasonably required at school. Once you clarify whether you are required to attend, my advice is that schools always ask for an appeal timetable. What are the key dates? When do you need my statement by? What other dates do I need to be aware of? And more importantly, what is the hearing date? And the hearing date, as soon as you know the hearing date, you check your calendars at school and first of all, check that it's not a bank holiday. The tribunal lists some bank holidays. Secondly, check that it's not a school holiday. Thirdly, check that you are not having an inset day or some other event of the school, a fair, a Christmas fair, etc. Any event of the school that would prevent a member of your senior leadership team or your SENCO, deputy head, etc., to attend the hearing. It's normally the case that the people attending the hearing on behalf of schools are SENCOs or your deputy heads. Generally, you don't ever see, I've never seen in all my years in practice, a teacher attending the appeal. So it's somebody a bit more senior, head of a year, head of a school, deputy heads, SENCOs attending the hearing. So check their diaries. Who do you think will attend the appeal? And you can look back at your consultation response to see who filled out the consultation response and do they know enough about the case, do they want to participate, etc. Once you know the hearing date, then you must diarize it, because the tribunal will not be pleased if on the day of the hearing you say, sorry, we didn't diarize it, we can't attend, can this be rescheduled? The tribunal is generally very reluctant to reschedule hearings because obviously there is a child at the center of the process, and the tribunal wants certainty, educational certainty for that child as soon as possible. The next thing that you would do when you get that request for a witness statement or witness participation is look back at your consultation response, where you consulted. If you were not consulted, then pick this up with the local authority and say, or with parents, and say, we were not consulted on this. This is the first we hear. How come you're calling us to the hearing? Because if anyone is proposing to name you, they should have consulted you in the context of EHC appeals. You then look at your consultation response and see, is it a robust response or is it a one-liner? Does it help you formulate your statement, or do you need to find more information and find out more about this child, whether it is the child is currently at your school or is a prospective pupil at the school? If you were consulted, then you will ask the question, what has happened since the date of the consultation? So has there been much progress? Do you have any further information about the child? Has something happened that it's important to mention in your witness statement or to note? So for example, are you having autism outreach support for the child, or is the child or young person on a part-time timetable? Have there been suspensions, etc.? So you're trying to piece that holistic view of the child. If the child is at your school, obviously, if the child is not at your school, you don't have the benefit of that information. Before you start drafting the statement and before you allocate the work, you need to ask yourselves, do you have everything you need? So has the local authority provided you with the latest version of the working document? And that's a really key question to ask, because at consultation stage, they would have sent you an EHCP as it was at the time, but things have moved on. And during the appeal process, parents would have been, if it is an appeal under BNF and Section I, or even without Section I, parents would have been feeding into that EHCP working document process, and the local authority experts would have as well. So the EHCP that you had at the time of consultation is likely not how it looks now when you're being asked for a statement, for a witness statement. So do please always ask, can we have, please, the latest version of the working document? The next point is, once you get the working document, check that you have also been provided all the reports that are cited in Section K of the working document. And this is because that's your source of information. You will want to see the latest educational psychologist report before formulating a view, etc. If the child is at your school, you will have all of these reports. But if the child is not, you're entitled to ask for these documents in order to participate in the appeal. At that stage, you will also want to see the grounds of appeal of parents. So what are they saying about the appeal? What is their main complaint? Is it not enough special education provision or incorrect description of need or all of the above. Does it include health and social care, etc.? You want to have a bit of an understanding of what the appeal is about. You don't need to read hundreds of pages just to have an overview of what is the appeal about, what am I asking to be involved in. You can also ask the local authority or parents, if parents are the ones asking you to participate, for any private extra reports that they may have. You will, if the child is at your school, you will already have your local authority reports. If the child is not, you won't have anything. So all of that information is going to feed into the process of preparing your witness, or preparing towards completing your witness statement. Taima, please, the next slide. I think we've missed one slide there. No, sorry, we haven't. Sorry, Taima. Let's move on one slide. Apologies for that, everyone. So general principles about the witness statement. Witness statements should be in first person and signed by one person only. Sometimes in tribunal hearings, you have a statement that has been signed by 2 or 3 members of staff. The tribunal are not happy with that. They want to know who wrote the statement, and it needs to be written in first person. So I am the SENCO at the school. I have been at the school X number of years, and this is what I know, or this is my position on the appeal. The second point is that your role as a school, as a witness, you're not a witness to one of the parties, you're a witness to the tribunal. This is an inquisitorial process. So the tribunal views witnesses as assisting the tribunal panel reach a decision rather than assisting the parties. And this is particularly the case with the schools. So you need to form your full, frank, and independent view of the appeal. Sometimes the schools come under pressure from local authorities to take one side or another in the appeal. It's important that you do not, because the tribunal panel at the hearing will really drill down on issues around impartiality and independence of witnesses, and they will want to know that you have formed your view based on your own understanding of the case and your own preparation towards the appeal. So where the child attends the school, you'll be drawing on the school's experience of the child, what you know of the child. Where the child does not attend the school, you'll be drawing on the consultation response and also on all the new documents that are coming in the appeal, which we looked at in the previous slide. Thank you, Taima. Next slide. So what do you include in your witness statements? Local authorities often will send you a template. You do not need to follow that template. You can follow it if you like. The problem with those templates is that sometimes they serve one purpose, so they're one-sided, and they're not asking all of the relevant questions. So my advice is that if you get a template, by all means, start using the template, but you should really try to address all of the points on this slide. So first of all, give an overview of your school. Tribunals deal with hundreds of schools a year, and they just don't know your school. So they want to know what sort of a school you are. So go back to basics. What type of school are you? A specialist school? Are you an independent school, mainstream, etc.? How many pupils do you have at the school? How many of those are on the SEN register? How many of those have EHCPs? You can give a brief overview of the expertise within the school. So what's your structure? Do you have a SENCO or a deputy SENCO? How many do you have learning support assistants? Do you have HLTAs, etc.? So all of that general information that will be relevant to the tribunal will come into understand what the expertise on the ground is and what the school looks like. If you have a couple of buildings, then you can talk about that, or a unit, or a resource space, etc. So give that general bird's eye view of your school. The second point is you would want to talk about your understanding of the child's SEN and disability, if applicable. And if your child is with you at the school, you will hopefully have a very good understanding, and you just give a description of what you think the child has in terms of SEN at the school. And if the child is not with you at school, you will still insert a couple of paragraphs on the child's SEN. And this is because the tribunal want to make sure that you have an understanding of this child, even if it is a basic understanding, if the pupil is not at the school, but that you understand diagnosis or needs, etc., and that you set those out at the outset. The next point is your views on the proposed placement, if this is Section I appeal, and I should have added there also your views on sections B and F, if it is a BNF appeal. So do you think, if the child is with you at the school, do you think that the EHCP is fit for purpose, basically? And if the child is not with you at the school, you can make comments on BNF and say, I see on Section F, for example, that there is reference to ABA, it doesn't fit with our model, or I see reference in Section B to hearing impairment, but I don't see any health provision, etc. So you will be critically looking at that document and stating your views as you would in any professionals meeting. With regards to the views on the proposed placement, if there has been a consultation, you are perfectly entitled to change your views. It may be that the local authority consulted you when the child's EHCP was very basic, it didn't have a lot of provision, and when the appeal comes to you, the EHCP has really changed, and the working document that you have in front of you presents difficulties or new areas that you hadn't considered at consultation. So you're perfectly entitled to change your view from the consultation stage. You would have to give reasons as to why you're doing so, or you can not just change your views, but you can add to the consultation reasons that you gave at the time of consultation. If you are a local authority, a school, and disagree with the local authority, again, the tribunal will want to hear from you on that point in your witness statement. It is obviously up to you how you manage that relationship with the local authority, and the same applies obviously to academies. Next, the local authority will look at, the tribunal will want to know details of the proposed class, and that includes how many children in the class, how many of those have SEN, how many have EHCPs, a broad description of needs, obviously without any data being released there. Learning levels, that's something that is often overlooked in witness statements, that the tribunal is very interested in. What are the learning levels within the classroom? And what are the staffing ratios within the proposed classroom that this child or young person will join? And what type of staff will you have in the classroom? Is this an HLTA, a TA, a teacher, a couple of teachers, etc.? So all of that information will help the tribunal make the decision that they have to make. You will also include wider considerations around suitability of peer group, pupils' well-being, the views of the child, and I have a separate slide on the views of the child. You can also talk about costings. So if there is something in the plan that you think you will have to secure separately, you can talk about costings if it's a Section I appeal. And that's because in Section I, the tribunal has to look at the cost of placements for both sides, parents and the local authority. And finally, and very important, witness statements, if possible, should have appended documents to them, so evidence in support of your views. So this would be, for example, progress reports of the child, if the child is at the school, assessment data, risk assessments, anything that might be relevant to the determination of the issues under appeal. And if you disagree with sections B and F, or also with placement, it also helps, if the child is at your school, to supply a sample or a few samples of the child's work. So as you know, sometimes you will disagree with the local authority on the suitability of your school, and you think that the child may need to move to a more specialist setting. Supplying those samples of work is very important, and the tribunal has 2 expert members that know how to look at this, who are educators or have been working in the education field, who will be able to understand what the sample of work is telling them. Next slide, please. With regards to the child's or young person's views in relation to placement, if it is a Section I appeal, often in an appeal, you will see that the local authority says on the papers, we will seek the child's views at some point on placement, and then that's not done unless the parents have private experts who are seeking the child's views. It's really, really important that if the child If the child is at your school, it's very important that you try to elicit the child's views. You can talk to your educational psychologist, you can talk to your local authority, etc. If the child is not at your school, and this is views about placement, and it would have to be done with the consent of the parents. If the child is not at your school, you should ask the local authority, what are the child's views with regards to the proposed placement? And there is a very recent case, it was only decided just before the summer, against Liverpool City Council, where the child in this case was age 7, had ASC and another SEND. It was an appeal against sections B, F, and I. The local authority favoured a maintained mainstream school with an SRP, and the parents had requested a non-maintained specialist school. The child in question had attended some sessions at the non-maintained specialist school and was attending sessions in some afternoons with some regularity, and had expressed really strong views against the local authority's school. The tribunal did not consider the child's views and did not make specific findings placing weight on the child's views when looking overall at the decision of placement. And the APA tribunal found that there was an error of law and sent it back down to the first year tribunal for a new decision. So that is how important the child's views are in this process. Next slide, Taima. So liaison with parents and the local authority during the appeal process is very important that you remain independent, as I've said earlier, and also that you are transparent in all the dealings with the parties in relation to the appeal. You are perfectly entitled to, if you want to fully remain independent and not be drawn into the dispute, if you're emailing the local authority about something or parents, you can email them both and say, I need to have a bundle, or I need to have this document, so could you help me understand this, etc. So it's really important that you maintain that impartiality where possible. And just a reminder that parents can make a subject access request during an appeal, and they often do make those requests during an appeal where there is dispute as to a school's placement. I dealt with a recent case a while back, it was actually a while back now, where parents made a subject access request, and it turned out that the local authority had fully annotated a witness statement initially drafted by the school, and the school had adopted all the annotations without questioning it, and the tribunal took a very dim view of this. The local authority and parents must send to SENDIST whatever you provide them. So a school your witness statement and any appendices. It is good practice for schools to ask whoever has asked you for the witness statement and the documents to ask for confirmation that they have been sent to SENDIST and to the other side. And this is because it's not unheard of a schools to come into the appeal hearing and to be said, to be asked, where is your statement? And then turns out that the local authority hasn't served the statement as they should have. So when you send the witness statement and appendices, please ask them to confirm, to send you confirmation that they have been sent to parents and the tribunal, or to the local authority and the tribunal. Schools must not communicate directly with SENDIST. Schools are not a party to these proceedings, and therefore you can only communicate with the parties, but not directly with the tribunal, and the tribunal will tell you that much if you try to communicate directly with them. If there are any changes on your participation or your ability to participate in the appeal, please tell both parties as soon as you know. So can you not attend the hearing, for example, then let them know as soon as you can, because the parties may decide to apply for an adjournment or to apply for other measures from the tribunal in relation to your participation. Next slide, Taima. So now, preparing to attend the actual appeal hearing, you will have decided when you were in the statement who was going to be attending. So you need to make sure as a leader at the school that that person is going to have sufficient time to prepare for the appeal. Try to block some time if you can, and I know this is very, very difficult on the ground, but try to block some time, a couple of hours, for them to really become familiar with, again, the witness statement, the documents, and the documents in the appeal. And I say become familiar because sometimes you will be asked for a statement in September, say, but the hearing is not until March. So at that point, you may have forgotten what the appeal was about or the precise details of your position as a school. You should also ensure that you have the notice of hearing. It's a very important document, and we're going to pause on that in a minute. You should also ask the local authority, and it is the duty of the local authority to provide this, not parents. You should ask the local authority for the appeal bundle, for any late evidence, and the latest version of the working document. Those are the 4 key questions that you need to be emailing them about. Please send me the notice of hearing, appeal bundle, late evidence, latest version of the working document. And you need to make sure that the member of staff that will attend the hearing will have easy access to these on the date of the hearing. The tribunal is, during your evidence, whoever attends the hearing will ask you, please can you turn to page 285 of Tribunal Bundle 1, and then you don't want to be scrambling in your emails to find that tribunal bundle. I always recommend local authorities for size restraints often send appeal bundles in sections. I always recommend, if you can, collating all of those sections into a single bundle so that you can quickly scroll up and down rather than having to open multiple PDFs. The tribunal will have a single collated bundle, and they won't be able to guide you on this page is in part 1 or 2 or 3. So it's important that somebody perhaps in your administration does that. You will find out who is attending the hearing for both sides. So who is who, so that when you come to look at that screen, sometimes with 14 faces, you know who is for parents, who is for the local authority, and who is asking you questions. If you can only attend for a slot of time, you can ask the local authority in advance, well in advance, the local authority or parents, to make this request to SENDIST. SENDIST understands that the schools are busy and that your professionals are busy, and that perhaps for whatever reason you can only attend, for example, in the morning of the hearing and not the afternoon. Next slide, Taman. So I think, I am afraid we weren't able to make this any larger, but when we share the slides, we're going to share this sort of dummy notice of hearing with you all, so that you can understand what it is. This is an important document to have before the hearing. This tells you, well, who is the child, first of all. It also tells you the date of the hearing and the time of the hearing. The hearing can be an all-day hearing starting at 10 a.m. or an afternoon hearing or a morning hearing only. All hearings are by video unless otherwise ordered by the tribunal, for example, because the party needs reasonable adjustments or prefers the hearing to be held in person. You will have to be free from 9:30 onwards because you have to run a test to test your connection between 9:30 and 9:45. And this will enable you to make sure that you're going to attend the hearing and be seen and be heard, etc. And the test you run is with a clerk of the tribunal. So it's a person in their administrative section. You should use Google Chrome as your browser. It works best. Some people use Safari. It doesn't present any problems. You will be sent a link. So the notice of hearing always contains a video link that you have to click. If you can't click on it, and sorry, forgive me, but what I've put numbers because I've deleted the actual video link, but it will normally be a longer link. If you can't click on it, you can cut and paste into your browser, and that will take you onto the Ministry of Justice's SENDIST website. And that is very self-explanatory. You just insert your name, you say you're a guest, and you click connect. And once there is a drop-down menu as well for video and audio settings, you choose both the video and the audio, and then you connect and you wait. Quite often there is a delay. You will see a page with some logos of the tribunal and the tribunal's court service, and you just wait for the clerk to come and fetch you from that lobby. When you are logging into that page, you will see an alias at the top. I think it's the top left-hand corner of the page where it gives the send room. That's the virtual tribunal room where you are. So if you have connected here using the link above to send room 6, and then you connect to the hearing and up on the corner says send room 7, it may be that the system has sent you to the other room, but in any event, just wait for somebody to come and fetch you from that room. You will click connect. If you have difficulties, the notice of hearing always has a number that you can call, and there is a passcode for each appeal that is individual to each appeal hearing. So any problems at 9:30 when you're running that check, call them. There is always somebody answering that call. And well, here they say, yes, be patient, etc. And you can send them an email. I wouldn't hold your breath on sending them an email. They're very busy. They want replies. So persevere on making that phone call. You can either call this number at the top on page 1, towards the middle of the page, you see a telephone number. That's the technical support team. If you absolutely can't get hold of anyone and you can't, nobody's responding to your emails, etc., then you call the number at the bottom of page 1 of the notice of hearing, and that will direct you into the hearing just by telephone. Schools often ask me, can I just connect by telephone? The answer is you shouldn't. You can only connect by telephone if you're having technical difficulties, but the tribunal want to see people's faces. It's only fair to parents that they know who's speaking, and it's much easier for the tribunal to understand the proceedings if they can see the person who's speaking. It is also important because you may have participants with reasonable adjustments, for example, hearing impairments, and your attendance in video is much preferred in those cases. The second page of the notice of hearing is important as well, because there, towards the middle of the page, top middle, there is a section on behalf of the parents. So the other people here will include, in the notice of hearing, the tribunal will include the names and the roles of the people that will be attending the hearing with you. So in this case, you will know, do you have educational psychologists for both sides? Is there another school attending? Are the parties represented, etc.? And this gives you the who is who. And the final point I wanted to make with relation to the notice of hearing is that it's important when you attend the hearing that you have your calendar at hand, just in case the hearing adjourns for whatever reason. If the hearing adjourns, the tribunal will ask you what dates you have to avoid. Next slide, Taima. So now, attending the EHCP appeal hearing, we've gone through the notice of hearing. This is a very important document when you're expected to be a witness. Always ask for it to make sure you have it at hand. Run the test, we've already talked about that. The last bullet points are important. The last 2 bullet points, if more than one member of staff is attending the hearing for whatever reason, then, and this would be quite unusual, but if that were to happen, then you have to log in from separate rooms and computers. If you don't have separate rooms, you can log in using separate screens, headphones, and putting yourself on mute appropriately. What you cannot do is use one screen for 2 faces. The tribunal asks that there is always a face per screen. It is also much easier for everyone to know who's talking and for parents indeed. SENDIST appeals are private and they're conducted in private. So you must be in a private room without any interruptions. People cannot pass you papers. They can't come into the room. They can't say, sorry, Holly, can I speak with you for a second? They're absolutely private hearings. You must not be interrupted. So please put a note on the door of the room where you are sitting, or let everyone know. You cannot be in an office where you can be overheard and there are other people around. So you're going to have to find that private space. What I have found over the years is that often those attending appeal hearings decide to work from home on that day just to be able to have that level of privacy that is required for these private proceedings. Next slide, please. So in terms of who you will see there on the day, in addition to the people that are listed in the notice of hearing, you will see a panel, and that will be comprised by a judge who's obviously legally qualified, plus 1 or 2 specialist members. Specialist members of the tribunal are non-lawyers, they're non-legally qualified, but they're experts in the field. So often you have maybe a former or current education psychologist and a speech language therapist or a head teacher or somebody else that has been connected and has expertise of education. So you can expect their questions to be fairly detailed and granular. They will have quite a bit of knowledge in the field of education, and particularly in the field of special educational needs. You can have hearings that go for a full day. Full day is normally 10 o'clock until 4:30, although it can run a bit longer, but generally the tribunal tend to keep them at that. And half-day hearings, either 10 to 1, so morning hearings, or afternoon hearings, 2 to 4:30, and that detail is given in the notice of hearing for you to see. The procedure on the day will very much depend on the panel, and this is one of the questions that I was often asked when I was at the bar, is like, what happens on the day? And it's very difficult to predict. Some judges are very formulaic. Other judges are very fluid and like to conduct the hearing in a very informal way. So it very much depends on the judge. But what is certain is that the judge will tell you at the outset in the morning how they're going to conduct the hearing. So they will say, we're going to look at section B, then we're going to look at section F, then section I, or we're going to look at everything together, or I want to hear from the schools first, or I want to hear from whoever else is in the room. So do not worry about it. The panel will guide you through it, and they are normally quite assertive at deciding what procedure they're going to follow. The first people always to speak in this sort of hearings, quite rightly, are the parents or the young person. So you will hear from them first, and after that is very much dependent on your judge and your panel members and the issues at hand. And the panel will tell you when you're required to give evidence. Normally, they issue some sort of guidance at the outset, so we don't expect to hear from the school until 2 p.m., or we don't expect to hear from that expert until 1, etc. Witnesses must not ask questions of any other witnesses, and indeed not questions of parents, without permission of the panel. The panel will very rarely grant permission for you to ask questions to schools, so I would just say to schools, no questions at the hearing. Please, you can ask questions of the judge if you have a query about the procedure or you have a technical difficulty, but other than that, you must not ask any questions of anybody else present at the hearing. If you're allowed to attend for a time slot or you have to leave early, make sure that the panel are aware at the outset of the morning, because sometimes they've been presented with a huge amount of evidence and bundles, etc., and they've missed the fact that you're only going to be there from 11 to 12. So if you have that slot, you are free to lift your hand. There is no emoji for lifting your hand in the platform, so you have to physically lift your hand. The tribunal will get to you and just remind them, I am down to be in this hearing only from 10 to 12, and I can't attend beyond that, and they will note that. There's a small chat facility as well on the screen on the left-hand side. You can also flag that there, but it's just better if you lift your hand and let them know. It's obviously at the discretion of the panel whether they allow you to go home early, as it were. Next slide, Tema. So another topic that worries attendees at this sort of hearings is, what questions am I going to be asked? Well, the panel will ensure that the questions are appropriate to you and to your expertise, and that they're asked in a polite and professional manner. And my experience is that judges and panels are very good at ensuring that is the case indeed. The panel will not expect you to ask questions that are not within your knowledge, and will stop representatives from asking you questions that you don't know the answer to. So, and if they don't stop a question that you don't know the answer to, you're entitled to say, I am sorry, but that's not within my knowledge, and do not try to speculate. It's perfectly fine to say that is not within your knowledge, and if the panel feel that it should be, they will tell you. The primary focus should be on the child, and you will be focusing on the child, so you'll be talking about the child's needs, etc. The panel is not there to resolve disputes, for example, between the parents and the school, or complaints or parental conduct, etc. The panel is only interested in getting it right for this child in relation to his EHCP. You will come to the hearing well prepared and be ready to navigate your way around the electronic bundles, because as I have said, they may ask you to refer back to a page of the bundle. or to bring up a document that has been served late, or to look at the working documents. So you need to have all of those at hand in whatever device you're using. There will be frequent breaks during the hearing and a lunch break between 1 and 2 normally. If you require any reasonable adjustments or an earlier lunch break, you can again raise your hand and mention this to the tribunal. If you require reasonable adjustments and you don't want other participants to know, you will be raising this when you run that test at 9:30, 9:45 in the morning. You will be saying to the tribunal clerk, I require more frequent breaks, or I require whatever it is that is necessary for your full participation, and they will pass on that message to the tribunal panel. Next slide, please. So what happens if you cannot attend a hearing? I think I'm going to leave this for Rosie now. Rosie.
Thank you. So, of course, there are things that crop up in life. And so what does happen if you think you can't attend a hearing? Well, if you do identify that there's something that's come up that means you can't attend, you should be giving as much notice as possible. And the reasons for that, of course, then in the appropriate way. And as Miriam's touched upon earlier, as the school and educational professionals, you have a pervasive duty to act in the best interests of the child concerned. And that is particularly the case where the child is already at the school. And so it is really the expectation of the tribunal that you are there to provide that relevant information. As well, there is the option for the tribunal within the tribunal rules to require a person to attend via witness summons or require a document to be produced. And there are cases that happen where, for example, a school isn't in attendance and the parents and the local authority agree just prior to the hearing about the elements in question that's being appealed. And so, for example, if that is the case that your school is being named where you've considered that it's not suitable or it's incompatible, then you not being at that hearing is going to miss that important detail in the moment. So next slide, please, Tamar. So following a hearing, there are 3 possible outcomes for an appeal. So the tribunal panel and judge will either allow it in full, they will allow the appeal in part, or they will dismiss the appeal entirely. It's usual that you won't hear about the decision on the day and that the tribunal panel will prepare a written notice of their decision, and that's normally within 10 to 15 working days. Of course, if it is the case that the decision is to name your school and you've opposed the placement, you can then ask the parent or the local authority, depending on which is the relevant party in that scenario, about their intention to appeal that decision. But it is important to note, and we've put it here, if it is the case that your school has been named in Section I of the EHCP, you do have a duty to admit, regardless of whether there is going to be an appeal against that decision or not. As we said, you must admit in line with the tribunal order. We'll go and...
Rosie, can I just pause there for 1 minute? So appeals against Section I are non-suspensive. The only suspensive appeal, so the only time when you must not comply with an appeal order, if there isn't an onward appeal, is where is a decision in relation to ceasing a plan. In that case, that the plan will continue until the full appeal right is exhausted. Thank you, Rosie.
Thank you. Next slide, please, Tamar. So as we've just set out, so the effects on the school is that once they are named, it then has a duty to admit and use their best endeavours duty to put in place education and provision for that child. Of course, there are significant risks if the school does not admit that child. For example, as we've said here, breach of statutory duty, disability, discrimination claim by the parent against the school or responsible body, judicial review and parental complaints. But of course, every case needs to be looked at on the facts. And so if you do have concerns about where you have been named and that duty, we're here and we can talk that through with you to look to see how the school can put in place that practical support for the child to ensure that they can meet their duty in that respect. So next slide, please, Tamar. So we've come to the end now of our talk today, and we hope you've found that really useful. We've set out here for you some of the practical resources that VWV have created for schools and on the basis of cases and issues that we see schools deal with on a day-to-day basis. I will flag to you here, if you're not already signed up, I would encourage you to sign up to our Academies Maintained Schools law brief. That's a quarterly update that will give you updates on a whole range of education law specific articles and points for you. We are also able to support you as part of the EHCP response process. And so we have a huge wealth of resources and experience in dealing with those, and as well as Miriam's flagged with the EHC appeals. So if there are any questions, or if as a school you've been asked to attend, then we are always really happy to help and to tailor our advice as needed. So I think that then brings us on to any questions that anyone has for us.
So I think there is a question in the Q&A. If a child is non-verbal, but parents are appealing the placement, can we say that child's views are unable to be given due to the nature of their SEND need? I think you would make that a bit more nuanced. So what you can tell the tribunal is how the child presents at the school, and that in your view from how he presents, you feel that he's happy or content or is well integrated, etc. So you should still address the child's views by inference, albeit you can't ask the child and the child can't tell you directly. You could, for example, have a conversation with that child's TA and see how his days are going, etc. So you still need to address the child's views, even if indirectly. I see a question that simply says parental application. I'm not entirely sure what that question is. There's another question. How far in advance of the tribunal should you receive the official notice of hearing, and should this be sent directly from the court? So in terms of it being sent directly from the court, no, because you're not a party to proceedings. So the court will not communicate with the schools in the same way that you will not communicate directly with the tribunal. In terms of when you will receive the notice of hearing, ideally, you receive it as soon as the local authority has it or parents have it, whichever party is calling you to participate. And that is, I can't remember how many weeks it is, but it's a good few weeks before the hearing that you will have that notice of hearing. The next question, so it's at least 4 to 6 weeks, if not longer. The next question, so I have somebody saying, in a parental application, the local authority said yes to assess, but not to issue. The parent is appealing, parent has asked me to advocate. Is that allowed? So no, you shouldn't be acting as an advocate for parents. Advocates can access support through SENDIST and other services that are provided by the local authority for these purposes, and you can direct the parents to those purposes. What you can do is, if you disagree with the stance taken by the local authority, you can provide information to parents that parents can use in that appeal. So you could provide a letter, or documents, and you can also say to parent, I'm willing to attend the hearing to support you at the hearing. Parents would then inform the local authority that they are calling you to give evidence at the hearing, and then you would have to have a witness statement, etc. Obviously, you would have to manage carefully that relationship with your local authority and how that plays out in practice. But yes, you can help parents and support them, but you can't advocate for them or appear at an appeal hearing as a parental representative. There are services for that, free services for that. And you can meet the parent's lawyer. Yes, you can meet with the parent's lawyer. There's nothing stopping you from doing that in the context of a hearing, but just remember that you must remember impartial and objective throughout. So you're a witness for the tribunal and not for parents. And yes, you can meet with the advocate prior to the hearing. There's nothing wrong with that. Local authorities often, when they're calling their schools that they want to come to the hearing, meet with them prior to the hearing to go through the issues and talk about the hearing and so on. I'm sorry, but I'm having questions in the chat as opposed to the Q&A. So I'm just going to move to the chat and read a question that's there. Do parents need to go through mediation procedures if they're appealing Section I? Is mediation applicable to some types of appeal? I think parents have to go through mediation if they're appealing Sections B and F and not Section I. Yes, from memory, I think that's the case. I can double check. Sorry, mediation is so peripheral in this appeals, unfortunately, that I don't have the answer at the tip of my tongue, but I can come back to you in a minute. How can you effectively get the point across that you're oversubscribed and don't have capacity to admit anymore? We have shared the challenge for space, but been told that by court that physical space is not taken into account. Well, so thank you for this question. How can you get the point across? You can get the point across about inefficient education of others, which I think is what you are asking here, by supplying the tribunal with as much information as you can. Just making reference to a space may not be enough, because they will be looking, if you're making reference to a space as presenting a barrier, you need to say how that lack of a space affects your ability to make provision for other children at the school, specific children at the school. So you have to look at, can you provide therapeutic support, for example, during the classroom if you have those space constraints, the health and safety considerations, but you are primarily looking at, are you able to educate those children, including therapeutic support, if you lose those square meters. When the schools want to defend their position on the grounds of space, I advise them to provide plans of your site with space, and then you can also provide them the DFE. I think there is a DFE note in there. I can't remember the name now at the tip of my tongue, but it's a DFE note on require space in schools, etc., and make reference to that. But you have to always link it back to specific children. So X child would not be able to have occupational therapy if we are losing this space, because we don't have any other space where occupational therapy could take place, for example. Another question, and I'm sorry if I miss any of this. I have tried to make reference to health and safety concerns to meet needs of existing students, etc., accessing OT. Yes, well then keep trying. You have to keep trying, but you must remember that proving incompatibility with the efficient education of others is a very high threshold. It's very, very hard to prove. Even if you're above PAN, oversubscribed, you can't fit one more chair, etc. But it is possible, and appeals, the tribunal is receptive to this. the problem is that sometimes the schools make very generous statements. You have to tie it to individual pupils. So you have to talk about, I have seen, for example, schools, especially schools in particular, which are really struggling with the space, to make a table. And within that table, they insert the name of one of the children, and sorry, not the name, an X or a Y, etc. And then they say, for this child, we're not going to be able to make this provision. It is in the EHCP, and therefore we would be in breach of our statutory duties and so on. And then they do that analysis, child-specific analysis, obviously not disclosing any personal data, no names, etc. And you have to consider, if you're a very small school, whether the parents would be able to know which child it is, in which case you can't go into that level of detail. I hope that helps with your question. Is there, are there any more questions? I'm just going to give everyone a minute or two. Yes, we have another question. What would be a response if the local authority has concluded that specialist provision is appropriate, but they have named a mainstream school due to lack of specialist places in writing to school and parent? So the response by the school, I assume you're asking, is that you agree with parents and the local authority. In this case, I assume, if that's the scenario, that specialist provision is appropriate for the child, and then you set out your reasons as to why your particular school, mainstream school, it would not be appropriate due to lack of specialist support, etc. It is not, so it is a breach of local authority statutory duties to place a child in a mainstream school against parental wishes solely on the basis of resources. That is unlawful, and I understand it happens in more cases than like it to happen. So you maintain your position, if it is your position, that a specialist provision is required, and set out the reasons. The tribunal can make a preliminary decision at the hearing that they disagree with the local authority, that the local authority cannot use mainstream schools as placeholders until a specialist setting has a place, and can send the local authority back to conduct consultations for specialist schools. And this happens often. They make preliminary findings in sections B and F, or a preliminary finding with regards to the type of a school, and then they say to the local authority, go back to the drawing board and look for specialist schools. And this is where a parent has required, just to be clear, this is where the parent's wishes are for the child to attend a specialist school. I got a question again in the chat. Is it unlawful for the local authority to refuse Section K documents, and what if they do? Well, I mean, I'm not sure it is statutorily unlawful, albeit the SEND Code of Practice does require local authorities to cooperate in all matters related to SEND. In the context of an appeal, you should have all the information that you need to prepare for the appeal and to understand the child. So yes, I would say that there is no valid reason for the local authority not providing you with the Section K documents, and that they should provide you with the Section K documents, and you can refer back to the duty to share relevant information with all stakeholders that is in the SEND Code of Practice. Just giving everyone a couple of seconds. I don't see any more questions coming in. So with regards to mediation, mediation is not, just going back on this point, yeah, so you can mediate in the appeal. Yes, they would have to have done mediation on the appeal. Right. I don't think we have any more questions coming in Thank you very much all for coming. We hope that this has been of assistance. Our emails are there in the last slide. Our team will email you the slides for you to have, and I think you also get the recording. Yes, you get the recording as well. And there is a little feedback poll at the end, which I think has appeared on your screen, that we asked you to complete if you had a minute. So thank you very much, everyone.
Thank you.